We will go right ahead and call the first case, which is a mini oral argument on the application. It is People versus Krukowski and Stevens. Ms. Williams, you'll go first. You have 20 minutes. You can reserve some of that if you like. And by the way, welcome back. And Mr. Eggert and Mr. Dunn, I understand you're splitting time, and Mr. Eggert will proceed with 15 minutes of that time and Mr. Dunn with 5 minutes. And I see nodding, so I'm going to assume I am correct. And you can proceed, Ms. Williams.
Thank you, Chief Justice. Good morning, and may it please the court. My name is Heidi Williams, and I represent the appellant, the people of the state of Michigan in this matter. I'd like to reserve 5 minutes for rebuttal. This case presents what I think is a unique opportunity for this court to clarify the scope of a statute that has proved troublesome to interpret and difficult to apply in practice, the second-degree child abuse statute. First and foremost, the people are asking this court to provide guidance in this area of the law. That said, we believe this court should reverse the decision of the Court of Appeals for 2 reasons. First, sufficient evidence presented at trial supported beyond a reasonable doubt that defendants committed the offense of second-degree child abuse under the prosecutor's intentional and/or reckless act theories. The Court of Appeals rejected the intentional act theory because it improperly analogized the circumstances of this case to those in People versus Murphy, and because it concluded based on its common sense that giving a very young infant multiple bottles of water was not likely to cause serious physical harm, despite that this conclusion was contradicted by the testimony of medical professionals who testified at trial. Second, defendants' failure to seek professional medical care after their 9-week-old infant sustained a known and traumatic head injury constituted willful abandonment, as that term is used in MCL 750-136B1C. I'm prepared to address these arguments in turn, but at this point would be happy to entertain any questions the court might have.
Thank you. Justice Markman, we'll start with you.
I have no questions now, thank you.
Justice Zara.
None at this time.
Justice Viviano.
I have no questions either. Thank you.
Justice Bernstein.
Good morning, counsel. I just have one question just so I can have a fuller understanding of it. Under your reading of the law and the statutes, if somebody were to, let's say, have a child and they rode a bike and they didn't have a helmet, would they be subject?
Simply for allowing the child to ride a bike without a helmet, Your Honor?
Yes. Just under kind of how you would interpret it. I understand it's like a little bit of a challenging question, but I'm just trying to get a sense of how you would interpret it.
Yeah, so I guess, Your Honor, if you're talking about the intentional act theory, again, a potential problem I see with your hypothetical of a parent allowing a child to ride a bike is the question of then,
Not without a bike, but without a helmet.
Okay, excuse me, without a helmet.
Right.
I don't know that you could identify an act on the part of the parent in that circumstance. So then I think you'd be addressing it under the omission aspect of second-degree child abuse, which requires the occurrence of serious physical harm. So I don't believe a parent could be culpable under your hypothetical under an intentional act theory.
Okay, but going on a little quicker further, what if there was an injury and the child did sustain injury, but they were allowed to ride the bike without a helmet?
In my opinion, Your Honor, that wouldn't, even if we were saying, under a willful abandonment theory, in my personal opinion, that wouldn't fall within the scope of the term omission or abandonment as that has been defined by the legislature.
Okay, thank you, counsel.
Justice Clement.
No questions right now. Thank you.
Justice Cavanagh.
No questions.
I have one question for you, Ms. Williams. What meaning do you give to the word willful? It's not just abandonment, but normally in the criminal law, willful means, I think, recklessness or more, either intentional or reckless conduct. What meaning do you give to it in this statute?
Yeah, Chief Justice McCormack, I think I would assign to the term willful when speaking of abandonment. It would require, in my opinion, some kind of intentionality regarding the abandonment. So some kind of intentional conduct on the part of the parent. And here I think the facts of this case are sufficient to give rise to that intentional abandonment, because not only did the parents, let me back up for a minute. So first, after the head injury occurred on February 7th, the parents did not immediately seek medical care for the child. The record reveals that at least the mother had some medical training and background, and she reported then to the child's physician 2 days later that the child was inconsolable, incapable of being pacified, is how the physician described the child at trial, based on that doctor's appointment. And then based on the testimony of the medical physician, the parents did not reveal, the mother did not reveal that the head injury had occurred then, despite that the doctor specifically asked her, did a fall occur? And the mother denied that. Now, the defendants make much of the fact that the mother testified to the contrary at trial, but again, because we're reviewing this as a sufficiency of the evidence claim, all credibility determinations must be construed in favor of the jury's verdict. I would also point out that even after the child was seizing and the parents took the child to the hospital, according to the testimony of the emergency room nurse, Sarah Markle, and the emergency room physician, Dr. Kirby, both of them testified that the parents didn't reveal the fall until they were confronted with the CT scan findings showing that the child had significant brain bleeds in multiple stages of healing and a skull fracture. So all of those things, in my opinion, suggest, Justice McCormack, that the parents abandoned this child and that it was willful because the parents understood that the child was injured, right? And then the child continued to exhibit it, that it was in distress. The parents knew the child was in distress, and then they thwarted the efforts of medical professionals to provide appropriate care, both at the appointment on February 9th, and then finally when they took the child into the emergency room several days later.
And is it, I reviewed the jury instructions, and it looks like the judge instructed the jury about the peppermint water incident, but not specifically about the less than full information or lying to the pediatrician. Is that your understanding, and does that matter?
At least, well, Your Honor, so I think I agree with you, and that's a point I raised in a footnote in my brief when I argued that perhaps those acts of the mother of lying to the physician, if you construe that as an act, and then taking the child for chiropractic treatment, could potentially be used as independent, intentional, or reckless acts. But I agree that it's questionable from my reading of the jury instructions whether or not those acts were in front of the jury for an intentional or reckless act. Again, I think it depends on how you construe the jury instructions. My opinion, though, is so even if this court construes, though, that the jury instructions were insufficient to include those acts under an intentional or a reckless act theory, I don't think it matters when we're talking about the willful abandonment theory, right? Because the problem, in my opinion, under a willful abandonment context is, did these parents fail to uphold or comply with their parental duties in the face of dangerous circumstances and despite having a responsibility to do so? And I think that, their failure of conduct or their, failing to disclose this information to medical professionals when it was needed would still allow a conviction under the willful abandonment theory.
Thank you. If no one else has any questions now, you may reserve some time, or you want to go on with some of your argument. You have a lot of time.
I'll go on for just a couple of minutes, Justice McCormack, if that's all right. There are a few points I think I just want to emphasize. Regarding the intentional act theory, and obviously I'm aware that everyone has read the brief, but I think there are a couple of points that under the intentional act theory that would suggest that an opinion from this court may be warranted to clarify some issues that haven't been construed in Michigan case law before. And one of those, I believe, deals with the fact that when the Court of Appeals applied its common sense determination and said a child, it's not likely that giving a child water is going to cause significant harm. I think that raises a really interesting legal question that hasn't been addressed in any published opinion as far as I'm aware about, well, what is the kind of child when we're talking about serious physical harm? What kind of child are we talking about? In my opinion, the Court of Appeals seemed to treat the relevant child as perhaps an older child or a child on average, whereas the child we're dealing with in this case was 11 weeks old when the water was administered. So a very young child that has very different health needs than an older child. And I think that's a question, a legal question that this court hasn't opined on, and no published Court of Appeals opinions have opined on that either. That might be an opportunity for this court to provide some clarification. The defendants also raised the issue of mens rea regarding the intentional act theory. And again, this is an issue, and I brought up in my reply brief the Justice Weaver's concurring opinion in People versus Maynor. But this is yet another area of the law where, as far as I'm aware, there's not a published opinion directly on point. My reading of the statute says that when a parent, in order to be culpable under an intentional act theory, they need only intend to commit the act. They don't need to necessarily intend that serious physical harm will result as a result of their action. But again, I think this is something that needs to be clarified in Michigan law. And then finally, regarding if we move over to the willful abandonment theory, again, I would just encourage this court based on that an opinion should be warranted here to clarify the scope of the law. The Court of Appeals in this case provided a definition of abandonment, but it didn't provide any meaningful explanation about how that definition applied to the facts of this case or how it created a clear standard for cases moving forward. And although the court was construing a novel issue of statutory interpretation, it didn't publish its opinion, which gives us very little meaningful guidance moving forward. I think prosecutors have had trouble in the past few years knowing specifically how to apply the second-degree child abuse statute. And in fact, I've seen, one of the strategies is that because there is so much confusion in the second-degree child abuse statute, that prosecutors are sometimes making strategic decisions to instead charge first-degree child abuse, because the first-degree child abuse statute doesn't distinguish between acts and omissions and arguably doesn't constrain the people to a specific definition of omission that we don't have any clear interpretation for its scope. So for those reasons, we would encourage this court to issue an opinion here, regardless of whether it grants the relief the people are seeking. With that, I would just reserve any remaining time for rebuttal.
Thank you, Ms. Williams. Mr. Eggert.
Good morning, and may it please the court. Jason Eggert from the State Appellate Defender Office on behalf of Dane Krukowski. The evidence is insufficient to sustain Mr. Krukowski's convictions for at least three reasons. First, as the Court of Appeals correctly concluded, the evidence at trial only established an omission. That omission of failure to immediately seek professional medical attention is not covered by any provision of the second-degree child abuse statute, which limits the omissions that fall within its scope to willful failures to provide food, clothing, or shelter necessary for a child's welfare or willful abandonment. Second, even assuming the evidence established is an act at all, the act of allegedly giving peppermint water to their child is still insufficient to establish his guilt under a reckless or annoying intentional act theory. The prosecution cannot establish that Mr. Krukowski had the mens rea to commit the offense under either theory. As it relates to knowing or intentional acts, the prosecution failed to establish Mr. Krukowski either knew or intended that the likely result of giving his child peppermint water would cause serious physical harm to his child. For reckless acts, although mens rea is still a problem here, the prosecution cannot and does not argue it can establish his guilt under that provision because it requires that the alleged act actually caused harm and no harm resulted from giving the peppermint water. Third, the prosecution's argument that Mr. Krukowski and Ms. Stevens' parental decision to initially treat their child injury at home constitutes willful abandonment is not based on the ordinary meaning or definition of the term abandonment or a fair reading of the statute. To apply their approach here would create a sweeping catch-all provision the legislature never intended to create and would remove essentially all parental discretion on issues of medical treatment and force parents to take their child to the doctor for all potential injuries, no matter how minor, to avoid criminal liability. And had the legislature intended to take such a drastic approach, it would have expressly done so as it did in the civil child neglect statute. And finally here, that it's important to remember that this case had consequences for Mr. Krukowski. He spent 3 years in prison. He lost custody of his child and who is now healthy and in foster care. And with that, I'll accept the court's question at any time, but I may have additional points if there's any remaining time after the court's questions.
Thank you, Justice Markman.
Well, counsel, is it your theory that the reason that failure to provide medical treatment where necessary was not placed within the statute here is that the framers of this provision were concerned that absent any more specific explanation of the circumstances when medical treatment would be required, a parent would feel obliged to take their child to the doctor every time they bump their knee or scratch their head in some way. Is that the rationale in your view as to why we don't have an apparently more encompassing statute? This is not a very unusual kind of activity, taking a child to a doctor, and not taking one's child to a doctor where taking a child to a doctor would seem to be warranted, would seem to be somewhat threatening to a child under appropriate circumstances. Why is it not included in the statute here?
Well, I think part of the reasons are what you suggested, is that this is a touchy decision that's a matter of a lot of controversy with people, which is one of the reasons when you look at the civil neglect statute, where it does include that, there's still a provision for religious exemption. I think that in matters like this, where sometimes the extent of the injury is unclear or maybe internal and requires an MRI to actually determine the extent and nature of the injuries that occurred with the child, it presents a very difficult and essentially discretionary decision by parents that they have to make on a day-to-day basis. A bump on the head could be insignificant, it could be severe, and where parents have to act is to decide whether maybe giving someone Tylenol would be sufficient, or whether it requires maybe a trip to the ER or just a urgent care or their primary care physician. So I think one of the reasons they did limit it is for the reasons you stated, and due to this, how squarely this falls within day-to-day parental discretion.
Thank you, counsel.
Justice Zara?
Questions?
Justice Viviano?
Questions. Thank you, counsel.
Justice Bernstein?
No questions, thank you.
Justice Clement?
No questions.
Justice Cavanagh?
No questions for me either.
Mr. Eggert, you may continue if you would like to use any more of your time, or you may cede it.
Okay, I think I just have an additional point here. I think, and it's regarding to the prosecution argument about an apparent ambiguity in the statute. I think that's simply not the case. There's a clear rubric in the second-degree statute that lays out several options for prosecutors to decide. It lays out and defines the types of omissions that fall within its scope. And when we have those types of things, we apply the ordinary definitions of those terms, and making a discretionary decision on childcare isn't that. Where we have problems is where the prosecutors find something they don't like or think is wrong and try to punish it under the statute where the statute doesn't cover that. And I think it's, that's more of a frustration that should be taken to the legislature as opposed to criminal court when the statute doesn't allow for that. As it relates to Justice Bernstein's question earlier regarding riding the bike without a helmet, I think if you do apply the prosecutor's approach, that could be something. Riding a bike could be dangerous. If the child falls, that could be a reckless act. Giving the child the bike, saying, go ahead, ride your bike without a helmet, and then they fall, under the prosecutor's theory, that could fit. And I think that's an important point to remember regarding the scope of this statute, because I think an approach would create a very sweeping narrative here. And I think when we're looking at this, I think it's important to remember specifically with peppermint water that the fact that something could theoretically be harmful doesn't make the act of doing it criminal. And looking at these specific circumstances is one, Ms. Stevens was previously advised by a doctor that giving the peppermint water to a previous child was something that could be done to alleviate nausea. Second, the amount of water, according to the government's own expert, was not sufficient to actually cause the harm, although theoretically, if you gave the child too much, it could. And third, advice on best practices for childcare, whether it be diet, sleeping practices, what types of medications are appropriate for children based on age, are constantly evolving. What was okay for my mother when she raised me probably isn't okay now. And certainly what her mother, when she raised her, the practices she engaged in are not. And there's a real danger where there's what best practices are is constantly changing, that opening it up to discretionary decisions by parents on issues of medical treatment, it really doesn't provide notice to parents of what's appropriate and creates an environment where you better take that kid to the doctor or you may end up in court facing prison time. So unless the court has questions, I would cede the rest of my time.
Okay, Mr. Dunn? You're muted, Mr. Dunn. You just have to unmute yourself.
Thank you, Justices. It's great to be here. After 38 years, I finally made it to the Supreme Court argument. The Court of Appeals got it right. Criminal statutes have to be enforced as written. If there is an ambiguity that you can't seem to get around, and the People's Counsel admits there is that ambiguity, says so right in their brief, that it is very difficult to, because there's a lack of clarity, they say, in regard to the definition of willful abandonment, it's difficult to apply in practice. Well, that invites my rule of lenity argument. That absolutely invites my rule of lenity argument. The interpretation then, if there is an ambiguity, has to be construed consistently with the defendant's requested interpretation of the statute, which is what we have here. So the legislature could have said, well, we got food, shelter, clothing, and medical care before we get to willful abandonment of the child, but they didn't. The problem is nobody reasonably disagrees about food, clothing, and shelter as being necessary for a child, but you can have different doctors recommending different courses of medical treatment. That's the problem. And so we can't have a situation where trial judges have to guess at whether this particular recommendation for the child with these particular medical facts was reasonable or not reasonable. And so the only way to resolve this, in my opinion, is the way the Court of Appeals did. As to, now the people did a great job going through their brief. I enjoyed reading it, all of these different state interpretations. But the Michigan legislature needs to do this, not the Pennsylvania, Oregon, or New Mexico legislature. And the definition that I really like, modern definition, and is what I put in my brief, it's the Michigan Governor's Task Force, present Michigan Governor's Task Force on Child Abuse and Neglect, defines abandonment as leaving a child because the parent does not want to or is unable to take care of the child's health and welfare. That's not what we have here. And the child endangerment statute, cited also by the people, really is of no help. And so really what the legislature was doing in that definition is saying either one of these three they didn't really do, or complete willful abandonment. They just dropped the ball and didn't care about anything. I think that's the most reasonable interpretation that we can have of the statute. I know I'm rambling here. I know I only have 5 minutes. It's hard to squeeze me into 5 minutes, but unless there's questions.
Does anybody have any questions for Mr. Dunn? Seeing none, we will return to Ms. Williams for some rebuttal.
Thank you, Chief Justice McCormack. I have 3 points I'd like to raise in rebuttal. And the first is that the defense goes to great efforts to characterize the facts of this case as a normal exercise of parental discretion. And in the opinion of the people, this was not a normal exercise of discretion. So you have the bathtub fall that occurred on February 7th. And if that was the only circumstance in front of the court, I would agree that it would be a closer call whether or not the decision to bring a child in for medical care would be sufficient to support criminal culpability. Perhaps not. But that's not the only fact we have in this case. The record supports that after the fall occurred, the child was upset, could not be pacified for days. And when they took the child to a physician, the parents specifically hid the fact that the fall had occurred, right? Thwarting the opportunity of a medical professional to perhaps provide appropriate care. The mother then, based on the lie, based on our reading of the record, and again, this court is to construe the testimony and the inferences that can be drawn from the evidence in favor of the jury's verdict. The mother then took the child for chiropractic treatment based on the lie she told Dr. Dawes. And then after the child began seizing, they administered the water. And when they showed up to the hospital, they again did not disclose to medical professionals the fact that the fall had occurred, right? And the injuries in this case were not minor, they were extensive. The record reveals that the child had 2 subdural hemorrhages that were in various stages of healing, had a 1/2-inch skull fracture, had a fractured arm, had multiple broken ribs in various stages of healing. This is a child who very clearly would have been in a state of distress. And defendants were aware of that fact, and despite that, failed to seek medical opportunity, and in fact even thwarted the efforts of medical professionals to provide appropriate care. So for that reason, this goes beyond the normal exercise of parental discretion, where a parent says, well, maybe I'm going to give my kid formula instead of breast milk, as the defendants raised in their brief. In our opinion, this goes far beyond the bounds of a normal parental discretionary decision in the care of a child. Next, I wanted to discuss briefly the use of the term omission, right? So the legislature has provided us a definition of omission as including a failure to provide food, clothing, or shelter, or willful abandonment of a child. Again, the people's position is that the term willful abandonment, as the legislature has used it, has to mean something, right? We're kind of left in a position where we don't have any case law on point, directly published case law at least now, addressing what the term willful abandonment means, but it has to mean something. In my opinion, from the way the statute is laid out, willful abandonment can't just mean any dereliction of parental duty, because as the Court of Appeals noted, the legislature specifically mentioned a failure to provide food, clothing, and shelter. And if it was just any dereliction of parental duty, then perhaps you run into issues with the specific mention of food, clothing, and shelter. And in the alternative, I also don't think, as Mr. Dunn has suggested, that the term abandonment can mean a total and absolute dereliction in giving up of all parental duties and rights, because it seems that if that were the appropriate definition of willful abandonment, that it would necessarily subsume the specific mention of food, clothing, and shelter, which was the issue that the Pennsylvania Supreme Court. I'm sorry, Justice McCormack, were you asking a question?
No, my fault. No.
Oh, I'm sorry. Okay. But that was the same issue the Pennsylvania Supreme Court in Commonwealth versus Skufka wrestled with in a very similar statute, including very similar wording, and concluded that the term abandonment in that context did not require a permanent and total abdication of all parental duties. Finally, regarding the intentional act theory, again, the defendant says, well, there wasn't necessarily evidence that giving the child water caused any of the serious harm that the child endured. And that is true, but I believe that the testimony of the medical professionals certainly provided that giving a child of this age water could cause serious physical harm. And then the people's argument is simply that it was then based on the other circumstances of this case, the traumatic head injury, and some of the other experiences the child had, being non-pacifiable in the days after the head injury, that the decision to administer water in those circumstances, it was up to the jury to infer whether or not that act of giving water was sufficient to say that could cause serious physical harm, even if, as the people admit, it did not ultimately cause the harm that the child endured. We believe that was an inference that should have been left to the jury's discretion and not for the Court of Appeals to second guess on appeal. So for those reasons, again, the people would ask that this court issue an opinion reversing the decision of the Court of Appeals. Thank you.
Thank you. Are there additional questions for Ms. Williams? Thank you, counsel. The case will be submitted.
Thank you.